Good morning, class.
Months.
Okay. I hope I'm audible. Class, I hope I'm audible enough.
Yes, sir, you are.
Okay. All right.
Yes, sir.
Yes. Well, I think it is safe for us to start now. This is 206 or 210 participants as we start. Okay. So last week I laid the foundation for discussion on trespass to land. And today as well, we are going to do a deeper discussion on the thought of trespass to land. And so by Wednesday, we are going to wrap it up by discussing various defenses and remedies. Okay, so I want to believe that you have also read ahead of time before coming to class. So at a particular period of time, I may be asking questions for purpose of engagement. So now I'll try and slide and share my slide as requested by some of you, but only to warn that this is still work in progress. Okay, so after Wednesday class, I'm going to send the slide to you when I'm done with adding few things that I want to add. But for purpose of today's class, I will just display the screen and I will speak to the to my slide. Then if you have questions thereafter, we can ask. Now, let me see. Can you all see my slide now?
No, sir, we cannot see it.
Okay. Okay, let me see.
Yes, sir.
How about this?
Yes, we can.
Yes, sir.
All right. Yes. Let me see if I can move this. Okay. Yes. Now, like I said, this is going to be a form of this is a work in progress slide. So you have lots to worry about. By Wednesday, when I'm done with the our final editorial of it, then I will send to the class. That will also guide you when you are reading. Now, today or last week, I discussed extensively the concept of trespass to land. And I started by giving a background that before you talk of trespass to land, it is apt for us to understand what land itself is about. A class rep, who is that one disturbing the class now? Who is that one disturbing the class? It's too early now. If that person is ready, they should let me know. I don't mind spending 1 hour waiting for the person to allow the class to set. Okay, so I try to discuss the concept of land itself, and I cited the word of Sir Edokun, who said that in its legal significance, it refers to any ground, soil, or earth whatsoever. And so this also includes castles, houses, and other buildings. So, and I mentioned the fact that they need to understand or to underpin the concept of land itself is relevant to the thought of trespass to land because we are talking about interference. So you must be able to interfere with something before it can become a thought. So therefore, any unlawful or unjustifiable means of interfering with land, I want to trespass to land. And so that explains why I gave that I clarified the term on land. So, and I also mentioned the fact that that land, according to Blackstone, incorporates all things of a permanent, substantial nature, being a word of extensive significance, including houses and other buildings. So this is to let you know that we're talking about trespass to land. We are not talking of maybe land alone, land in its raw state. Okay, so we also talk of the building on it. So then I also warn that this definition may not include or does not include the minerals found on the land. And this, our authority for this is the provision of section 43 of the 43, 44 of the National Constitution. You read it and for further engagements. So then from there we now move to trespass to land itself. And we mentioned that trespass to land is also called a trespass quarry plus some frigates. That this is committed where defendant without lawful justification enters upon land in the possession of the plaintiff or remains upon such land, directly places or project any material object upon such land. And so, and the most important thing about this thought is that unlike the thought of negligence, where you may require, you need to prove the cumulative element of the duty of care, breach of duty, damage to the plaintiff before the court can go ahead to advance remedy, the case may be. You don't need a proof. It does not require any proof of damage before you can make your claim in the thought of negligence. So then we look at the various examples of these thoughts, and I'll also briefly touch on what we call the defenses and remedies of these thoughts. And so the tone has been set for us to build on the foundation that I've laid last week. If the class understood my recap, I just want whether the class governor or one of you to say yes. Do you get the recap I just made now?
Yes, sir.
Okay, great, beautiful. So now, let's now look at the outline. Now, for this course, of course, we are going to look at the meaning of trespass to land. We're also going to look at the forms of trespass to land, and we look at the elements of the thought of trespass to land. Then we journey to defenses and the remedies, and the case may be. So now, by way of overview, let me see if I can project the slide in a. Let me see if I can project it to capture, to show the entire work. Okay, our slideshow. Yes, is it better now? Is it better? Clark,
Yes,
can you see the full
sir.
screen? Right, great. Now, yes. Now, so you look at the outline. So we examine the meaning of thoughts of trespass. We look at the forms of trespass to land, then the element of the thought of trespass to land, defenses and remedies. So now the overview. In this presentation, we shall be looking at the thought of trespass to land. This also demands the understanding of the legal meaning of trespass to land, the necessary element of this thought, including the forms and act of trespass to land. Then the presentation shall also look at various examples of these thoughts, defenses and remedies, if any. So at the end of this discussion, you should be able to do the following. hold firmly that trespass to land, I use the acronym TRTL for trespass to land. So hold firmly that trespass to land is actionable per se. Okay, then wait a minute. Okay, so hold firmly that trespass to land is actionable per se. They understand the basic elements of the thought of trespass to land, understand the meaning of trespass to land, examine the various forms of trespass to land, discuss the various defenses of trespass to land. They identify various examples of trespass to land. And why there's need for us to understand the various examples of trespass to land is because of the polling question that they come in the exam. So by now, who's situation of land? Samuel.
Sorry, good morning, sir. Yes, we can see the slide very well. It's like showing half of the slide.
Class, is that the situation?
Yes,
No,
sir.
you can see it here.
I can see some though.
I can see it here.
Okay, can you see it now? Can you see? Can you see it now? You can see. Let me go back to the.
You can see it, sir.
You can see it. So, Samuel,
Yes, sir, we can.
You can see it, sir.
Samuel, is there any issue from your end? I was trying to.
Yes, I can see, but just not
to get the
everything
slide.
actually.
Okay, did I go back to the? Did I go back to the?
Yes.
I go to the medium
Yes,
side. Okay.
Yes, it's better like that.
Okay. All right, it's okay like this. It's okay like this.
Yes, sir.
All right. So at the end of the discussion, I said we need to hold firmly that trespass to land is actionable per se, and also the element of the thought of trespass, the meaning of trespass to land, various forms of trespass to land, the various defenses of trespass to land. Then we need to identify various examples of trespass to land. Now, having said that, the key points to note is that to determine the issues and applicable rules in trespass to land, you need to ask yourself this question: is the interference with the possession of plaintiff's land justifiable? That question is very key, and we are going to understand
Hello,
the
sir.
why. What is it again now?
Sorry to disturb you, sir. There are certain parts of the slides that has been cut out.
I'm just in page 3 of my slide. Oh, no, sorry, page 5 of my slides. Which one again? Which one is cut out? Okay, what can you see?
I can only see is the interference with of the plaintiff's land justify. That's all I can see, sir.
Wow.
I think it's from your end, but you can see it clearly from here. You can see it today.
I can also see it here.
I can also see it.
Okay, can you see the next point? An entry upon another's land is tortious whether or not the entrant knows that he's trespassing.
Yes, sir. We can see it to the part
Yes,
of
sir.
erroneously
It's
believed
Sir,
that the land.
Conway
Very clear,
and George.
very clear, yeah, very clear.
Thank you. So that means it's the person's setting. No, it can't be my setting.
Yes,
Yes,
sir.
sir.
I've adjusted it
It's
now.
not your
It's okay now.
setting.
Thank you very much, sir.
All right. So thanks. So the first question that we are going to ask ourselves is the interference with the possession of plaintiff's land justifiable? That question is key. And from various authorities that have been that the court have looked at over the years, you understand this better when you read the case of Fowler and Lani. I'm so sorry you have heard of that case before. Fowler and Lani. I'm going to send all these cases to you in due time. Now, then, before Fowler and Lani, there's another case we call the League Against Cruel Sports and Sports. You saw in the slide. But these two cases will set the tone to understand why the interference with the possession of plaintiff land is necessary for us to know whether the defendant will be liable in tort of trespass to land. The question is the interference with the possession of plaintiff land justifiable? Now, so the idea as to whether it's intentional or unintentional is captured if we resolve this question as to whether the interference with the possession of plaintiff land is justifiable. Now, another thing we need to look at again is that an entry upon another's land is tortious whether or not the entrant knows that it's trespassing. Okay, so that's the follow-up to the question that I asked, whether the interference with the possession of places land is justifiable. And the case of Conway and George Wimpy and Co Limited 1951 is on all four to that particular point. Then Joliffe and the Wilmets, also 1971. So these two cases led to the credence that the entry upon another's land will always be tortious, whether or not the entrant knows that he is trespassing. And we have many cases that to this line as well. Now, also, it is no defense that the only reason for his entry was that he had lost his way, or even that he genuinely erroneously believed that the land was his own. So this is another point we need to look out for in these thoughts. And I will say that. Let's now go to the meaning of the thought of trespass to land. You see that I said I'm working on the slide because I was also working on the negligence on top of negligence with this slide before. So and it's good to send this slide as well to you on the thought of negligence. So you can see some of those slides under the thought of negligence. So just ignore it. Now, on the meaning of the thought of trespass to land, I've explained what Sir Edward Coke said about land itself. And I've also warned that it excludes all resources by virtue of the national constitution to be held in trust for the benefit of all Nigerian citizens. So minerals found on land and all that are excluded from the definition of land. Now, so the definition itself is that in the case of according to Wolfe and John Lewis, it says that trespass to land is a wrong committed against a person who is in exclusive possession of the land trespassed on. Trespass to land is a wrong committed against a person who is in exclusive possession of the land trespassed on. So, underline exclusive possession of the land. So, this definition shows that it is the person that is in possession of a particular land that can maintain an action against a tort result under the thought of trespass to land. So, in other words, as we are going to see later, even the owner of a land can be sued in trespass to land if he is not in exclusive possession. And so that's what Winfield and Lewis are said.
Please,
So, and
let me still get an appointment for today. Can I still come in?
Yeah,
All right.
class rep, maybe I should make it co-host so let me mute all these people that are disturbing our class. Because
All right, sir.
this interruption is just too demeaning. I can't find the class here. I can't find it. Please, where are you? Just talk. Let me.
So I'm here.
Okay. So please, let me mute all of them. I've made it. All right, thanks. Okay, so I was saying that a trespass to land is a wrong committed against a person who is in exclusive possession of the land trespass on. Now, so when the parcel of land which was trespassed on is in the lawful exclusive possession of another person, a suit in trespass is not maintainable by the owner of the land who has no right to immediate possession at the time the trespass was committed. nor can a person who has a right to possession or in actual possession of the land be liable for trespass. Class, can you see my slide?
Yes, sir.
Okay, so now that point is to show that trespass to land this with possessory rights as against ownership. But that does not mean that an owner of a land cannot also maintain an action. So it depends on who is in exclusive possession at the material point. Okay, so in the case of Olagemiro and Adagumbade, Universal Vulcanizing Nigeria against United Trading and Transport Company Limited, you have these cases before. I think I've given this case last week as well. So all the holdings of these cases point to the fact that a person who is in exclusive possession of a property of a land is the one that can maintain an action in trespass to land. So, and we have established the fact that in ethic and carity, that it's actually passive. The thought of trespass to land is actually passive, whether or not the claimant has suffered any damage. So it is not a defense to say that it not enter his land, but it not suffer any damage. So what we are particular about is that at every material time, a claimant must establish before the court that is in exclusive possession of the land before it can maintain an action against anyone. So a landlord can be liable for trespass to land. His family can be liable to trespass to land, and any other person who has not been authorized to enter the apartment or who disturb the exclusive possession right of the claimant can be liable in trespass to land. That is the definition. Now, so I'll probably go to various acts of trespass. So essentially, our definition says that trespass to land involves any direct interference with land in the possession of another person. So now, and like we discussed last week as well, as a general rule, trespass is usually a direct rather than a consequential interference with another person's land. So one of the classmates asked a beautiful question last week, that if the branches of a tree move or extend to the adjoining land, would that amount to consequential interference, or would that amount to direct interference? And we all agree that it is consequential. And so on that note, it will not amount to trespass of land, but rather it can amount to maybe a nuisance, as the case may be. So now, also in the case of Onosoya and Emmanuel, Lawani and West Africa Portland Cement Company Limited, these are the cases that have discussed in full the concept of trespass to land. And so, by way of definition, which I just mentioned with my slide, is that trespass to land, called trespass quarry plus means the interference with the possession of land without lawful justification. So the phrase quarry plus zone regis literally means breaking the clues of the plaintiff land. So in other words, interfering with the land of the plaintiff. So, and like I said earlier, it was heard in the Emmanuel's case that trespass to land is committed where the defendant without justification enters upon the land in the plaintiff's possession, remains upon such land, and lastly, directly places or projects a material object upon such land. So the formula is that that is when you enter into the land of another, then or you remain into the land of another, or you directly project material objects upon such land, then there's trespass to land. Trespass to land is committed. So those are the forms of the trespass to land that I'm going to explain as we go. Now, so let's look at the first one, the first form of trespass. Now, that is trespass by wrongful entry. According to Salman, it says this consists of a personal entry of the defendant or by some other person through his procurement into the land or building occupied by the plaintiff. So this definition shows that the trespass to land can actually be committed even by proxy. So if you authorize another person to enter into another man's land or to interfere with the possession right of the claimant, then you can be liable for trespass to land. So look at the cases of Pickering and Rouge. Then also in ethic and charity, of course, that was the first that I gave you last week. It was said that the slightest crossing of the boundary of the plaintiff's land will also amount to trespass. So here, the court was of the view that every invasion of property, be it so minute, is a trespass. So it's not a defense to say that after all, the intervention was not substantial. As we're going to see through the examples of trespass to land as we go on. So that's one. Now, key points here is that, which I've already mentioned as well, is that trespass is a wrong against possession rather than ownership. I'm reiterating these particular points so that when you see polling questions, you have to shine your eyes to know which particular rule apply to this particular question that you are faced with. And so does a person who has possession of the land can sue a trespass even against the owner of the land if the land was leased to him. Also during that period, the owner cannot sue in trespass concerning that land. So it is only the person who has the exclusive possession that can sue. And there are exceptions also to this rule. For example, where it is clear that the leasehold property is substantially being damaged, the owner can set in, the owner can come in and sue and maintain an action because, of course, of his right to immediate possession. He has a right to reversion. So that note, he needs to protect his interest from being deprecated or from being decimated. So that kind of expression that you have in this kind of points. Then you look at the Oguchi and the Iliasu. It was said that possession in this instance means actual possession. So and also the second one is trespass by the many on the land. We are looking to adopt on the first point as we go on. Now, the second form of trespass to land is trespass by the many on the land. Trespass by the many on the land. Now, a person, as someone say, can you come again with the exception? I cannot come again because only Jesus is coming back again. So, but just to do a recap of what I said, if we miss it, is that I said the owner of the land, we are saying that it's only the person with the possessory rights that can maintain an action in trespass to land. And I'm not saying that one of the exceptions to that point is that even the owner of the land, the person that has a reversionary interest in a leasehold property, if he sees that his property has been decimated, if his property has been damaged, because he has a reversionary interest, he can bring an action in trespass to land. So that's what I said. Now, so you look at the cases on the first one, on the first point I made. You can look at the case of this wrongful entry. You can also look at the case of ethic and charity that I mentioned earlier. They look at the case of Asby and White. So all the cases, I'm going to update the slide and send to you. Anyway, then for those that are interested in reading further, you can also look at the case of Basley and the Clarkson. I think I've summarized the facts of this Basley and Clarkson somewhere in a slide. So now let's move quickly because of time. So yeah, a person will be liable in trespass if he enters a land lawfully and he remains there after his rights as expired. Now, so it is the law. That's the second form of trespass to land. It is the law that a person is liable in trespass if having entered another land lawfully, he remains there after his right of entry has come to an end. The case in point here is Balogun and Alakija, you can read further in under we mentioned the fact that a person will be liable in trespass if he enters the land lawfully, but remains there after his right of entry has expired. I'm sure you are aware what happened in the case of Balogun and Alakija. So here, in this case, B was employed by A as a rent collector. So on one night, A called at B's house after business hours in order to demand an account of rent collected from him.
Sir, we can't hear you.
Hello, Clash.
Yes, sir.
I think I was locked out. Okay, I was locked out. Okay, so let me repeat that part. So I was trying to give you the background of fact of Balogun and Alakija.
So we can't see your slide. Your slide is no longer.
Okay, you can see the screen again. You can see the screen again.
Yes,
Yes,
sir.
sir, we can.
You can.
We can't see it for now.
Okay. How about that now?
Yes, sir, we can see it now. Yes, sir, we can see it now.
How about now? That's okay. Yeah. So sorry, but I think it's my network. Sorry. Yeah. So a person will be liable in trespass if he enters a land lawfully and he remains there after his right of entry has expired. So that was what Wilfred and Jelu said, and I was trying to use the case of Balogun and Alakija to explain before I was locked out. So now, in Balogun's case, the B was employed by A as a rent collector. So one night, A called at this house after business hours in order to demand an account of rent collected. So B allowed A to enter, but thereafter an argument ensued between the two of them, and A was asked to so B asked A to leave. Other than A to leave premises, he became abusive and assaulted B, and did not leave the house until after about 60 minutes thereafter. So the court held that where a person is lawfully on the premises of another, once his license or invitation is terminated, he is only allowed a reasonable time in which to leave, and thereafter he becomes a trespasser. So that was the order of the High Court of Lagos State at the time. So now this principle lend credence to the fact that if your initial entry was lawful, and along the line, your inviter decide to terminate your lawful entry after a reasonable period of time, you'll be liable for trespass to land if you refuse to leave the apartment of who invited you. And this is what happens on daily basis. Okay. You're invited by your friends, and along the line, something ensues between the two of you, and it suddenly becomes aggressive and unwelcoming. So at that period of time, what the civil should do is to take his or her leave, and otherwise the person can be liable in trespass by remaining on the land. So in case it's drawn out of this particular fact, you have to be able to contrast it with a continuing trespass. We're going to get there's still line between trespass by the meaning of the land and continuing trespass. So then the third one is trespass by placing things on the land. Trespass by placing things on the land. That is the third form of trespass on land. Now, it is trespass to place any material object on the land of another, or to bring any object into direct physical contact with other land without lawful justification, or the land without lawful justification. So, for example, to fire a gun into the soil is a trespass by placing things on the land. Okay, to drag a nail into or place a ladder against a wall is also a trespass by placing things on the land. To remove a door or window from a house and to encourage a dog to enter a premise, or to blow noxious gas into a house. And these are examples of trespass by placing things on the land. Now, quickly, someone asked a question last week as to whether an animal who strays into the land of the plaintiff or the possession of the plaintiff will be said that the owner has committed a trespass to land. And my answer then was that I said my answer then was always because of the law is that if the man is not aware, okay, at best the liability can only come on the liability for animal and not trespass to land. But in this case, where it is the defendant that encourage a dog to enter a premise or encourage any animal to enter a premise, that will still be in the ambit of trespass to land. Okay, so these are a sharp contrast that we need to familiar ourselves with. You know, like I said, the problem with law students is not that you don't know the law. Okay, but when you twist it a bit, or you tweak the fact a bit, then one will be confused into how to answer or to give accurate answer in that circumstance. So what's up for this also for purpose of test or exam? So I won't say more on that. Now again, I will go to the element of trespass to land. Now, the placing of objects on the land of is someone ask a question? Is someone ask a question? Is that anybody want to ask a question? Okay, so now it's essential for liability in trespass that the placing or projecting of the objects onto the plaintiff's land should be direct. I mentioned that part earlier as well. It must be direct. So that also was opined by Samad. So then if it is indirect, then there can be no liability on trespass, but only in nuisance. So example of that is that of the case of a tree that grows and the branches enter the adjoining land. So thus, for instance, to plant a tree on the plaintiff's land is a direct invasion and therefore a trespass. But to allow the root of a tree to spread from adjacent land and on that of the plaintiff is indirect and therefore in nuisance. So you look at the case of Smith and Giddy for that proposition. Look at the case of Smith and the Giddy. So Giddy is spelled G-I-D-D-Y. Okay. So now the distinction between direct and indirect invasion of land is illustrated by the case of Onosoya and Imane, which is being displayed on the screen. Now, in this case, the plaintiff complained that the defendant, in laying the foundations of a building, had encroached by about 10 feet upon land in the plaintiff's possession. So he also complained that the defendant had thrown water and refuse onto his land and had allowed excreta to escape from a saga onto his premises. Thomas J. said that the throwing of water and refuse on the plaintiff's land were direct acts and thus amounted to trespass, but that the escape of excreta was indirect invasion and therefore not trespass, but but nuisance. Okay, so can you see the distinction now between direct and indirect evasion? Okay, it's very difficult for someone to curtail the spread of excreta from saga. Okay, but when you throw a refuse, of course, that's a direct evasion. You throw refuse is an object. You also throw water. It's also a direct evasion. So please note this particular example very well for purpose of exam as well. Now let's look at the element of trespass to land. Now in all the definition I've given in since, there are 3 elements that must be present before there can be a trespass to land. And you can ask your predecessors. I enjoy stating the element of a particular thought, and I mentioned that during the course of my interventions when I used to hold forth for Professor Shiomba in your class. I mentioned that when you are reading about a particular thought, okay, a kicker is that you need to understand the element of each thought, the element to set you free. The element will let you understand what a particular thought is talking about, it's all about. Now, so for trespass to land as well, you must ask yourself that there is or was a direct entry on the land, remaining on, placing or projecting any object on or above the land. That's not enough. The fact that there was direct entry is not enough. The fact that the defender remain on the land is not enough. The fact that the defender places objects on the land is also not enough. The place must be in possession before you can maintain an action under trespass of land. It must either be in possession or it must have right to immediate possession of the land. So, and I've also given you during the course of my lecture that where someone has a universal interest and needs to quickly curtail a further damage to his property, you can maintain an action in torts. So in trespass to land. So then finally, you must also show to the court that the entry is without lawful justification. Of course, persons who are authorized to enter your property as a matter of rights, they have lawful justification. I'm talking about the officials, the police, the law enforcement agencies, where by way of statutory duty that they are performing, they have lawful justification to enter upon your land. Okay, and we're going to look at that under defenses next week. So these are the elements that should guide you when you are discussing trespass to land. Amotrayo, please quickly, be fast.
So I just want to ask, like,
less than 15 minutes ago. Amotrayo.
Okay. Yeah, I can hear you, sir. Good morning, sir.
Yes,
So my question is,
go ahead.
must the 3 elements occur together, or like one, you can have one and not have the others?
Now, in 2 weeks' time, I'm so very clear, we'll take you through the thought of negligence. There are something called cumulative elements. This statement must be present before you can talk of trespass to land. You know why? Look at it. We said by definition, we said without lawful justification. So you know what? If you throw object on someone's land, you remain on someone's land, you enter someone's land without justification, then there will be trespass to land. If you enter it with justification, there will not be trespass to land. So they must be present. This thing must be present, and you must also show that the person you are entering his land has possession rights or has right to immediate possession of the land. So this treaty must be present before you can maintain an action in trespass to land. Is that clear, Bolu? Bolu, is that clear? Because you
No,
understand.
it's right. Yes, it's clear, sir. Thank you.
All right. So now So we have other relevant points to note on trespass of land is to talk about trespass ab initio. Now, trespass ab initio, the word ab initio means from the beginning. So, the word ab initio means from the beginning. So, here, under the law, certain persons have the right to enter premises in the course of their lawful discharge of their duties. And I've mentioned them a few minutes ago. These include the police, the postman, delivery letters, consumer goods, inspector visiting manufacturing premises, electricity and the telecom personnel in the exercise of their lawful duties, firearms, firemen on inspection of safety gadgets on premises, and so on and so forth. So now the deduction of trespass ab initio means that when a person enters the landed property of another person by authority of law, which is distinct from permission granted by a plaintiff. So, and the person subsequently misbehave or abuses his right of entry by stealing, damaging, assaulting, breaching the peace, etc. You will see that that can also be termed as if the person's lawful entry, the person's initial entry was not lawful. So now the major distinction between trespass ab initio and trespass by the meaning of the land is that in one, under trespass by the meaning of the land, you had the permission of the plaintiff to enter the premises. Class, please, are you paying attention to this particular distinction?
Sir, please, I don't really understand this
Are you
very
paying
well.
attention to this particular distinction? It's very important. Who is talking? Is it everyone?
No, I'm the one talking. My name is
I'm
Teresa.
saying,
I can't.
okay, I'm saying just pay attention to this distinction. The important thing is that
Okay, sir.
the major distinction between the two, because I think there's a thing like between trespass by the meaning of the land and trespass ab initio. Now, the deduction of trespass ab initio, what that simply means that you enter someone's land and when your entry, so you got the permission through lawful authority, and I'm saying that the difference between the two is that in the case of trespass by the meaning of the land, your entry was lawful, your initial entry was lawful because you got the permission from the person under possessory rights. In other words, you got your permission from the plaintiff, right? But in the case of trespass ab initio, the deduction of ab initio means that when the person enters the land property of another person by authority of law. So look at it, authority of law. One is authority of law. Okay. So the other one is just by mere permission granted by your friend. So, and which is distinct from permission granted by plaintiff. That is when permission is granted by the plaintiff, majorly it's likely that of by the meaning of the land. But if it's by lawful authority, then that will likely be the trespass ab initio. You know, it becomes trespass ab initio because you have now abused the right given to you by law. Okay, so I would say that somebody misbehave or abuses his right of entry by stealing, damages, destroying, assaulting, breaching the peace. For someone that have a past question, you see that I think last year I asked a question around this area, and it has to do with a NEPA official when they went on the land of the plaintiff to carry out their lawful duty, started plucking mangoes. Okay, so that's stealing. So their initial entry was lawful, but because they have done an act which is inconsistent with the scope of the authorities, that will amount to trespass ab initio, and the law will treat them as if they entered the premises without any lawful authority. Praise.
Okay, sir. Thank you,
Go
sir. Please, I
ahead.
have a question. This trespass ab initio, you made mention that it is also granted by lawful
Okay.
authority. The only exclusion is that it's not granted by the plaintiff. However, what of cases where a police actually barges into a person's house to arrest the
Let me
person
just
and
run
probably
through the slide. I see have like almost the 12 slides to work. Let me run through the slide.
all
Please,
right,
your audio, I
sir.
can't hear your audio is bad. Let me run through the slide, then I'll come back to you.
Okay, sir.
Okay, go ahead, go ahead. You are clear now. Go ahead. You are clear. You are clear. Go ahead. Go ahead. You are clear.
Okay, sir. Okay, sir. My question is, what of a situation whereby the police actually barges into a person's house to make an arrest? Since you said it's lawful authorities, but not granted by the plaintiff. However, in the process of barging in, probably they broke the person's gate or the person's door. Will it also be considered as trespass,
Oh,
even
okay.
when they were
Well,
actually
you know it's
performing
bad,
their
but I got your
duties?
point. Yeah, okay. Now that will be part of exactly.
Sir, I can't hear you.
It's you, I can't hear, but I'm managing to hear you. It's your network. It's your network. But don't worry, I got your point. Your question is what of if the police barges in into your premises? Hello? What if the police or the security agency barges in to your premises without lawful justification? So that will be captured under the defenses to trespass to land. But just to quickly put the discussion into proper perspective, we are talking about the art in a lawful way. It is done in an inordinate manner, where it is done in a way that fall below the standard of the law, then that will not amount to doing things within the ambit of your authority. So we are going to look at that other defenses to trespass to land as well. Okay, so now, so the abuse relates back to its time of entry, i.e. from the beginning, and it becomes by operation of the law. So a trespass has been issued. So what does it mean is that it becomes a trespasser for the beginning, for the moment he entered. Even though his initial entry was lawful, but because he has carried out certain act that is inconsistent with the authority granted to him, then his entry will be deemed to have been unlawful from beginning of his entry. So under this doctrine, the is treated as if he had been a trespasser for the moment he entered the land, so that damages should be assessed on the basis of his entire conduct, and not merely his subsequent wrongful act as tortious. So that explains the question asked by police. So his entry was lawful, but along the line, he carried out certain acts that is inconsistent with the authority granted to him. Then his act will be deemed, it will be deemed to be a trespasser ab initio. Now, let's look at, so on that proposition, you can look at the case of Oxley and Watts. Look at the case of Oxley and Watts. Then look at the case of as what we call six capital case for what we call for exception. Look at the case of capital case for an exception. So Abolu again, let me first, because of time. Bolu, you have a question again?
Listen, I'm sorry for taking you back,
Okay,
but I just
so
thought
now
of
let's
a
look at the continued
scenario
trespass. Now,
Hello, sir.
Now,
Hello, sir. Can I ask my question, sir?
I can't hear you.
Can
Class,
I
can you
ask
hear
my
him? Or can you
question,
hear her?
sir?
I can't hear you, Bolu.
Hello,
I
sir.
can't hear you. Wait,
Can hear
go ahead now. Go ahead. I can't hear you.
Okay, sir. So I have a question under trespass by remaining on the land.
Go
Let's
ahead now.
say we have a
Continue.
tenant landlord
Let me end the
situation.
class. Let me finish the class. Let me go back. Let me go ahead. Let me go ahead. I'll answer your question later. There's no time. I didn't mute. Your network is bad. I can't hear you. Class, I didn't mute Bolu for now.
Yes, sir. She's on mute already. I don't know. I think it's slow on your end. That's why.
can hear her. It's you we can't hear.
Okay. Okay, you can't hear me.
No, sir, we can hear you, but the thing is, it is slow from your end. So when someone has spoken already, you are just probably hearing it. That's the issue, sir.
Am I audible? Kashrep, can you hear me now?
Yes, sir, I can hear you now. I can hear you.
Okay. My screen is being displayed. Confirm.
Yes, it is.
All right. So, but Bolu, you can ask your question now. You can ask your question before we move.
Okay, sir. So I have a question on trespass by remaining on the land. Let's say a landlord has a tenant that maybe has not been paying rent for a while, and then he gives him a quit notice, and then the time for the quit notice has elapsed, but the tenant refuses to leave. Does that and
No. Okay. That's also one of the exceptions to trespass to land. They were going to discuss under the defense. Now, the principle of trespass to land does not affect a tenant who owes over. Does not affect a tenant who owes over. So why? Because by statutory provision of tenancy law of respective states, the tenant cannot be held as a trespasser under the law. So he is a statutory tenant by law. So we are going to look at that exception when we get to the defenses to trespass to land. And of course, there's also a particular case that I'm going to comment to you as well. So that case will explain in detail why the tenants who else over cannot be regarded as a trespasser under the law. Okay. So, but then again, I read the case of read the six capitals case, which I also explained last week. Under as an exception to the trespass ab initio, then you for the recovery of our premises, like I said, he is not regarded as a trespasser. In fact, where tenants owes over or overstays in the premises, he has life or otherwise remains in possession after his tenancy has ended, or he remains in possession after a proper notice to quit served on him has expired. It does not thereby become a trespasser under the law, or even whether a trespass ab initio. The point is that in law, the residential and recovery of premises law of various states protect the tenants who owes over the premises he has let under the law. So the proper course of action is to landlord to go to court and get him evicted or ejected, as the case may be. So under the defenses, we are going to also look at the remedy of a landlord in this circumstance. Landlord is entitled to a claim known as mean profits. So he has a remedy to get a mean profit from the tenant who owes over. Okay, so that's how I can say, or what I can say about that one for now. Okay, so let's look at yes.
So sorry, can the tenant be charged to according to trespass of remaining in the land, just like you said, after the rent has expired and the law has already evicted the tenant properly?
Yes.
I mean, a claimant can bring the charge of remaining in the land, trespass of remaining in the land.
Why not? Why not? That is after he has exhausted ejection process. You know, efficient process in law has so many technicalities attached to it. So after he has exhausted the remedy under the tenancy law, then he can bring an action. Of course, he can be treated as a trespasser, just like any other person. Yes. Now, so let's look at continuing trespass. Now, so remaining on a land or leaving anything on a land after an initial trespass is a continuing trespass. Now, which act gives a cause of action and right to claim damages, what we call the day in the end, that is from day to day, until trespass is discontinued. On trespass is discontinued. Now, if you look at this particular torts, if you look at this, especially look at the case of the case of Clegg and Darden. The case of Clegg and Darden. So Darden is spelled D-E-A-R-D-E-N. Now, whenever a person lawfully enters another's land without lawful exercise, he is liable for the initial entry and additionally for the neglect, failure, and all refusal. Sorry, I put refusal to leave the land or remove his things from the land. So long as the trespasser or his things remain on the land, there's a continued trespass taking place, which gives right to the plaintiff to sue from day to day and claim damages from day to day until the trespass is abated by removal of the person or thing from the land. So this trespass to land gives rights to the plaintiff first to ask for damages from the day of the trespass until the trespass is abated. That is until the defendant removes the object he places on the land. If the man has left the land, but the object he put there still remain there, he's still be liable for continuing trespass. So that is called the there in them. That is from day to day. Now, so this kind of trespass gives room for the plaintiff to compute his claim in monetary terms from day to day until that particular trespass is abated. Now, in Lagide and Oyelara, for example, the defendant laid the foundation of a building on the plaintiff's land, which he failed to remove. The High Court held that the defendant was liable for a continued trespass on the plaintiff's land. And in fact, the defendant had stopped going to the land is not a defense to an action for continued trespass. So even though he had left the land, but the fact that the foundation he built there is still remained there, he continue to be liable in trespass to land. Okay. Now, but contrast this. If the person has left the land, the person has removed the object he put in the land, but that he put in the land has defaced the land. For example, if someone dug a hole in the land, okay, but he has left the place, and all the instruments that he put there to dig the hole, he has left them. Can the person still be liable for continued trespass? Hello, class. Can the person still be liable for continued trespass?
Hello, sir.
Yes.
Sir, I don't think so.
Why? Well, what give you that firm belief that they don't think so?
I think, well, from what I read, I read that a person that does something that has an effect on the land is not liable for like putting it back into place. That all he's liable for is like the initial act of doing that thing, but he's not liable for like fixing it or putting it back in place. All he has to do is like leave but he's going to be liable for any damage that occurs as a result of the thing he has done. For instance, he's going to be liable if someone falls into the hole, but he's not liable for leaving the hole there.
Brilliant. So I just gave you the case of Clegg and Jade. So that case will help you a lot. So you contrast that case with the case of Lagidi and Oyila. So so cases of continued trespass must be distinguished from cases where the consequence of a trespass and not trespass itself are continuing. So in the case of Clegg and Geddy, so where the court held that he will only be liable for the original digging. Okay, so he's not liable for the omission to restore the land to the same condition in which he found it. So now, if failure to fill up the pit will not amount to continued trespass. But like you rightly mentioned, you will still be liable for any injury that is caused to a third party on that particular land. So I think that's straightforward. Okay. Now, time may not permit me to go through trespass and above and below the surface of land. So if that permits me, fine. Yeah. If that does not permit, that will be the beginning of our discussion next week before we go on defenses and remedies. So now, who may sue in trespass to land? Of course, based on our discussion, an owner of landed property may sue. Okay, so depending on his interest in the land. Okay, so because if it's the one that is in possession at the material point in time, then he can sue. The person claiming trust for the owners, caretaker can sue, agent can sue, attorney, manager, trustee, person in local parentis for a child, servants, and so on and so forth can sue. So these lists are innumerable. They are legion. So I only put up a few of them. So then tenants can sue. Of course, I'll discuss that. A holder of reversionary interest can sue. So a person that will entitled to possession after the tenant yield of possession, so can sue. A subtenant living under his value sublease can also sue. So when you're a tenant in an apartment and you yield part of your flat or maybe a room out of a 3-bedroom flat to another person under a rent, that person can also sue. Okay, so a purchaser who has not yet taken possession can also sue. Someone has bought over a property and yet to take over the possession, but he discovered that they are committing nuisance, they are committing trespass on that land, you can sue under the law. A trespasser or adverse possession whose trespass has matured into ownership. In foreign level, we are going to be doing a land law. Another land law, you'll be taught adverse possession as a concept. So where you stay over on someone's land for years, okay, and people are seeing you as the owner of the land, okay, you can also maintain an action. You are called an adverse possessor. If a trespasser can sue, a trespasser who has been in a possession for years, he can maintain an action against a co-trespasser. So because his trespass has matured to ownership. Okay. So of course you can look at a trespass by relation. So under the doctrine of trespass by relation, a person having the right to immediate possession who entered the land in the essence of that right is deemed by legal fiction to have been a possession from the time his right of entry accrued, so that he can sue for any trespass committed during the period he was in fact out of possession. So if a leaseor or a landlord is entitled to re-enter after termination of the lease, he may bring an action against trespass committed during the time of during the pendency of the lease. Okay, upon his re-entry. They call this trespass by relation. They call it trespass by relation. So then also we have another one known as trespass as between co-owners. So as a matter of law, co-owners have what we call unity of possession. So in other words, they cannot maintain an action against each other. if you are co-owners, you bought a property jointly, you enjoy it in common. You cannot bring an action against each other. The only thing you can do is that you can ask the others who have tampered with your interest in that land to give an account. That's the only remedy you have under the law, to give an account. So then examples of trespass of land, of course, I've mentioned that slightest entry of land, leaning, okay, leaning on the face of the land, refusing to live and remaining on land after permission is revoked, putting anything on land or projecting anything above land, walking on or crossing another person's land, sitting on another person's wall, so then using a private landed property as a shortcut to get to another place, to your home, without lawful right of way, properly given. Driving animals into another person's land, I mentioned that earlier as well, throwing refuse or anything to another person's land, or getting any object into the soil of another person's land or immediate airspace, and so on and so forth. So there are many of them. Now, I also ask question where trespass will be committed. Trespass to land will be committed in so many ways. Airspace above the land. So I'm going to start my discussion next week by God grace with airspace and the principle of Kujus Estulu. Then you have what's called air surveys or land surveys, beneath the hard surveys or underground, such as by tunneling or mining of mineral resources, and so on and so forth. So then, as general rule, entry below the surface of the land or entry on the above space, if it takes place within the area of ordinary use, is trespass. So we throw more light on this next week. So you can see the authority that I mentioned. Now, so in summary for today, liability does not arise in respect of flights which are not as reasonable height in the air. I'm going to decode that next week. Exclusive possession in trespass of land means actual or constructive possession. So therefore, mere physical presence, mere usage of control of land does not translate into possession. A servant in a house cannot sue for trespass, neither can a visitor on the premises, because they are just licensee. So a person cannot bring an action on the basis of de facto possession. The person will not be able to bring an action for trespass that occurred before he got into the possession rights. Precious. Let me just run the summary, then I'll come back to you. So then a person who is entitled to some interest in land will be able to sue for trespass. Just let me run the summary, I'll come back to you. So let me run the summary, I'll come back to you. So there are a person who is entitled to some interest on the land will be able to sue for trespass. We have mentioned that earlier as well. So then I should know that the person who has no title over land, but who has been put in possession, can bring an action against any trespass on the land, as possession without the legal title is sufficient. So I've also mentioned this earlier. So then look at the case of Fatuki, Olaninyo, and so on. So now here, interference need not be substantial. It is sufficient if it's a mere interference with the place's right to possession. I mentioned that earlier. Unakamba and Eze is clear on this. Then whatever the form of interference, it must be direct and immediate. It must be direct and immediate. So I have sources here for now. So a question from Precious first. Precious, then we'll go to Amarachi.
Sorry, sir. I heard you say that next week. So
Next
I thought
what?
they said you said next week that we'll continue our classes next week.
Monday now,
I thought
Monday.
they said Monday is when we are. Okay, but they said Monday is when we're having our holiday now.
Who says? Who says?
They said 23rd, sir.
What do you say?
They said 23rd. That's when everybody's going on for holiday break.
Where are you now? The question I want to ask: are you not at home? Are you not at home as you are speaking to me? Are you not at home? I'm asking now. Are you not at home as you are receiving the car? Are you not at
home, sir.
Where are you?
No, sir. I'm not at home. I'm out in Ibadan. I'm in Lagos, sir.
Well, by law, you are not in school. So that's by law. So if I have my timetable, let me look at my timetable and show you. I'm to take transfer to land. I will take transfer to land in 3 classes. In 3 classes. I started on Wednesday. Class rep, please bear me witness. When did I start my class? I started last week Wednesday.
Yes, sir.
Am I correct? So okay,
Yes, sir.
and so I'm having, so my class is supposed to end. I started on the 10th. So 10th to 16 will give me 3 days for transfer to land. So I've only taken a class, and the class I took Wednesday. I told you that I ought not to have taken that class because I was not permitted to take the class. When I was setting the YouTube link was when my mom was advised to refer that I will be taking the class, and I did a background of what transfer to land should be. So today is even actually the first time of taking the class. But if you know you don't want to class next week, then I want to go and read up the rest of transfer to land. So today is 16.
Yes, sir.
16, yes. So by the schedule, I was also end my class. I think they made a mistake in the what they said to me. But the Christmas break starts on the 23rd. On 23rd. So 16 Monday.
Yes, sir.
Monday be what? What date is 23rd? What date is 23rd?
Sir.
Monday. Monday.
Yes, sir.
Monday. So
yes, sir.
If Monday is 23rd, I would advise you that we take another class that time. If you don't want to take the class, then I will include my slide and send to you. So go and read defenses and the remedies. So I think what you say? So go and read. No. There's so I will not take your holiday. You have your
But sir, we have class on Wednesday.
On Wednesday, yeah. So okay, we have a class on Wednesday, and so if I have a class on Wednesday is on the 18th, and so that's what I say. If I'm saying next week, you should know that I'm talking about next class. Okay, so we have another class next this Wednesday. So, but even though you are okay with what I've done so far, I will just give you I will send this letter to you. They go and read on your own. After all, this is the era that you have to read on our own. So,
sir, you also promised to teach us how to answer TORTS questions during the holiday.
But if someone's already saying that if my brother is saying that they have holiday on 23rd, and I say let's have.
I'm not saying no. Sorry, sir. I just wanted to know when we'll be having holiday. That's just my question. It's not that I'm saying anything. I'm not saying anything.
Do you know what about holiday? You know we are on live, so and that's why I'm being very careful. Holiday is something that should be personal to you. For me, I don't go home on holidays. In fact, that is time I take time to read. As an undergraduate, I exhausted holidays for my personal readings and for my tutorials. My friends will stay back. I will go to class. I will take my classmates tutorials. We have tutorials back to back. We didn't know what was called Christmas break. We didn't know what was called Sabbath break. So, and you're even lucky you're online. So if the only thing that I will not do is to schedule a class during your service period, maybe church in the morning. But in the evening, if you don't mind, we can also arrange a class. I don't have the time, but because of the love of your class, I can always make myself available. It depends on you, but I don't want somebody to come to go and report to the school that a lecturer is taking us on Saturday, on Sunday. That's why I said during the holiday, I'm going to create some classes with you so I can put you through on how to answer the question. But if you don't need this, fine by me. I'll let me go and spend my holiday with my family. So that's what I can say for now. So now Paul Unaji, your hand is up. You have the floor. I'm done. But if you have to ask questions, you can ask questions now. Paul.
Okay, sir. Yes, sir.
Yeah, okay.
So I just wanted, my question is with respect to trespass ab initio.
All right.
You said, so does trespass ab initio nullify like the legal significance of something a police officer, for example, has done before he did the unlawful act that caused the trespass ab initio? So, for example, now let's say a police officer goes to someone's house and conducts a search or something like that, and he comes up with evidence during the lawful search. But then after that, he now does something that is unlawful that can cause trespass ab initio. That is the evidence he got during his lawful search of the house before the trespass, before he did the unlawful act, still like admissible or useful in courts.
Thank you. Who was that question? Is that Paul that asked that question? Paul. Is that Paul?
Yes, sir.
Okay.
Yes, sir.
Can you please lower your hand now so I can? Yes. Okay, I will know that. Yes. So now that's a very good question, and I must say that whether you start your law of evidence, you understand this principle very well or better. Now, we are talking about individual. So his conduct, the conduct of that person will be treated as if he was a trespasser from the beginning, that he had no lawful reason to be on that property at all. But on the evidence, the law of evidence will tell you that it does not matter how evidence is got. It does not matter how the evidence is got. Okay? Once an evidence is relevant to the fact in issue, the court will go ahead and admit that evidence. The weight may now be an issue. That evidence he has gotten can be used against the person in the court of law. Okay, but we are talking about his own entry will be deemed to be unlawful. Paul, I hope that has answered your question.
Yes, sir. Thank you, sir.
Yes, great. Okay, then Daniela, I saw Daniela hands up as well.
Yes, sir. Good morning, sir.
Good morning, Daniela.
Okay, my question is, you said that a servant cannot bring an action for trespass to land. But what is it possible for a servant that has been living in a house for a very long time, let's say for years, is it possible for him to become an adverse possessor, which will enable him to sue?
No, not at all. Don't forget the concept. The concept is that if you're a lodger who maintain an hotel, a room in a hotel for years, as long as paid for an hotel, for maybe a room in a hotel for 2-3 years, that does not make him a tenant. So on that note, he does not have possessory rights. You know why a servant may not be able to maintain an action in trespass is because he is not seen as someone in possession. He is not seen as someone in possession. He has someone that he reports to someone. So and again, is on that property at the will of the person who has possession. So it doesn't matter whether I spent 50 years on that premises. Okay, so that does not change the status. And that's why the law say licensee, lodger, servants, they cannot maintain an action. So the fact of the case, you say that it has not become an adverse possession. Adverse possession is another technology on its own, where someone owes over. If the person is seen as an adverse possessor, he's no longer a servant. It may be a servant, but he has not taken over the premises that people now see him as an adverse possessor. Then he can maintain an action. He or she can maintain an action. But if everyone knows that he's a servant and he reports someone, then he cannot maintain an action at all. So, Assistant Adekoya, we have 4 minutes to go. I'm being reported for housing.
Okay, good morning, sir.
Right, go ahead.
So my hand has been up since.
What do you say?
My hand has been up since.
Okay, who is that? I'm looking at the screen, so I don't know who is that person.
So my hand too has been up.
Oh, okay, quickly. Let's take you. Let's take assistant for assistant. Okay, I've seen 3 others, assistant and 3 others. So let's take assistant first. They'll go to Amarachi. They'll go to Gabriela. So go to Gabriela. Oh, yeah, let me first.
All right, sir. Okay, so my question is, in a situation where the police is chasing a criminal and then in that along the line, the criminal jumps into another person's compound, then the police barge into that compound and in the process they destroy like a property or something, does that still cover them under lawful authority?
Now, don't forget that ordinarily before the police can come to an apartment, they will need, it depends on the nature of the case. They will need warrants. I'll be aware of that. They will need warrants and all that. So if the warrant does not cover the adjoining premises, yes, they may require the permission of another person to enter the premises. Okay, so and that's why I'm saying that if the police now move to the adjoining premises to effect the arrest of the suspects, okay, the fact that they arrested him there will not be an excuse to say that no, you cannot take him to court because you arrested him in a wrongful place. So the owner of that apartment can maintain an action against them in trespass. Of course, by the time you go to defenses, you will see some qualifications of all these points that we have discussed. But the arrest will be intact, but barging into the adjoining premises may enable the person who has possession right to maintain an action against them. So we are going to look at the statutory authority and look at the qualifications. It is the law that determines the length of liability of the security agencies. Okay, Assistant, I hope that answers our question a bit.
Yes, sir. Yes, sir. Thank you.
Okay, then
Favor.
Okay, Amarachi, yes, go ahead.
Yes, I had a question from last class, but I wasn't able to ask. If I want to understand if thoughts would overlap certain times. If a person throws a ball into another person's compound, that's trespass. But if the person that they threw the ball into his or her compound refuses to let the other person come in and collect it, is that what's the other is that compulsion?
Yeah. Now by the time you talk of that next of topic I want to discuss, trespass, the word could use estolu. That is that will relate to quick plantation society. Whoever owns the land owns anything beneath and above. So if you find ball on your premises, I don't want the person who threw the ball to take it. Under the law, you are covered by the principle of a quick plantation solution. You whoever owns the land owns anything above, below, and above it. And that's why when someone got judgment in court against someone who has trespassed over his land, and that land has the trespasser has built on the land. If the owner got judgment from the court, he owns the building on it, anything above and beneath it. So he has a discretion to release the ball or to hold on to the ball. But you know, as I'm going to see later on the last day, you will discover that even an action will not normally be brought for trespass without damage, unless the claimant wishes to deter persistent trespassing, or there are disputes over boundaries or right of way. Favor, do you get the point I'm making? Ordinarily,
Yes,
that art of train ball by application is a minute act. It's a minute act, and you know, because of the principle in ethics and charity, which says that no matter how minute is trespass, and that's why we are talking holistically that these are trespass actions, okay? That the person with possession rights can maintain an action, but in reality, an action will not normally lie under trespass without damage, unless the claimant wishes to deter persistent trespassing, or maybe there are disputes over the boundaries or right of way. What I simply means that the law also wants us to be tolerant of each other. So it's not everything that you just go to court. Otherwise, you are going to flood the court with litigations. If you take every minor things to the court, you know the causes of de minimis non qualis. You were taught under your identity stage. When you not taught de minimis non qualis, class, I'm putting to you now. Were you not taught under the de minimis non qualis under your Samuel Injurious Adamno? People answer me now. Were you not taught de minimis non qualis? The law deal with trivial issues. So, okay, please, the housing class is on. The housing class is on, and I would like to go and see if I can join them. This is 2 minutes past the meeting, so they won't enter until I'm in. Okay, so on that note, we have exhausted our time. Okay, I wish to skip.
Let me quickly ask this one.
I wish to skip. 3 minutes is gone. No. Okay, go ahead. 10 seconds. 10 seconds. Be fast.
Thank you, sir. Sir, you know, you initially, when you were explaining the introduction of trespass to land, you told us to take note of the fact that it's only those who have exclusive possession and not ownership of the land that can bring the suit. However, we were now explaining further in the class that under those who can sue under trespass to land, you mentioned owners of the land.
Yes.
Isn't that contradicting what you said initially?
No, not at all. You know, I qualify it. Owner of the land can bring an action, but emphasis is on possession. Emphasis is what is on possession. So, and I've given you instances where the owner of the land can bring an action. If the owner of the land is also the one in possession, you know, if it's the job possession, you can bring an action. So, and I also said that if it feels that is waiting to be in possession may substantially damage his property, his reversion, it can also bring an action. You know, for every principle of law, there's always an exception. Those exceptions is what made the law. But that has not changed at all. Our general belief of view is that only person in possession can bring an action. That's the foundation. But there are qualifications here and there, and that's why we are explaining all the qualifications. We will continue next Wednesday by the grace of God. Class, I wish you a fruitful lectures for today. Thank you for having me.